Good afternoon, everyone. Welcome. I am Karen James here with the Rikoon Group, and I have with us today Stella Pederson. I'll give you all an introduction to Stella in just a moment. This is our second, I will say, in a series on estate planning. We started with a presentation a month ago on the foundations of estate planning. And then we've had so many conversations with clients over time about equal distribution, family dynamics around estate planning. And so that we thought this would be a great subject matter for today. And certainly if you have family or friends or, children, future beneficiaries, with whom you might want to share the presentation, the replay will be available for that as well. And it's always available on our YouTube page. Let's go ahead and get started. So Stella, thank you again for joining us today. For those of you who aren't familiar with Stella, Stella Pederson is here in Santa Fe. She's been practicing law since 1995. She is licensed both in Washington State and here in New Mexico. And she's worked across a broad range of practice areas that include corporate law, real estate planning, and probate and trust administration. And Stella recently stepped into the role as president of Heritage Trust, an independent trust company based in New Mexico. And I'm also very proud to have been in the 2024 Leadership Santa Fe cohort with Stella. So Stella, welcome.
Thank you for having me.
So you and I have had a few conversations in preparation for this event, again, about the idea of equal versus equitable inheritance. And I wanted to give you a moment to sort of speak to your experience around that. What are some of the initial questions that arise? How those who are in the midst of estate planning come to you, and what are their initial concerns in that regard?
Well, frequently, people don't really know what the steps are in estate planning and what kind of is standard and how you leave things to your heirs. Most commonly, we're talking about a family, that has parents and children. In the nuclear family, it's a little bit easy, right? Because the children are the children of the two parents. And so our baseline that we normally start from is equal shares for each child. That way, if you treat someone differently, you're not creating hard feelings necessarily that are left behind after you're gone, and there's no opportunity for closure. But very quickly, family situations are different. And so what is equal isn't necessarily equitable or fair. For example, one of the most common ones that does come up is you have a special needs child, and that child is going to need more resources than the other children. And so that might be a situation where equal shares isn't equitable because that child is going to need more resources or more care later on in their life. And one of the conversations that we have with people that do have a special needs child, if equal shares is appropriate, or even if it's not, we recommend that you set up a special needs trust so that that child does get a piece of the estate. Sometimes families will think, well, my child is on Medicaid and can't have assets, so I'll just leave it to the other children and they'll take care of them. And that is not a situation that usually works out very well, because first of all, that child feels like they haven't received anything and somehow they've been disowned because of their disability. And so they feel less valued as a member of the family, and it creates some weird power dynamics between the siblings. In my own family, we've seen that happen. My husband's grandmother his mom was disabled, and so she left the estate to the other two sisters. And so not only did it affect the relationship between those sisters, but it's trickled down to the following generations, the cousins.
Oh, interesting.
So it really kind of broke that family.
Well, and I know, so if we go back and we look for a moment at when equal might make the most sense. Maybe, I know, stages of life is one factor. So if everyone is in a similar stage of life, perhaps the parents have given equal amounts for college. There's not one child with tremendous student debt, whereas another, went to school debt free. They're all making a similar wage. They're all, and again, we're speaking to also a nuclear family potentially right now. They're all making a similar wage. They're all maybe a similar age in life. There isn't someone who, again, is further along. So certainly that is a scenario where it might make sense to just have an equal distribution. You have 3 kids, just divide it in thirds. When, I can think of a few scenarios where it might make sense to assign different amounts. What are some examples and scenarios where you've seen that makes more sense than trying to do it equally?
A lot of times parents will try to help their children while they're still alive, right? Make the gift now because the child can use the gift sooner. They will, buy a
What we
house for
call
a
warm
child.
giving. Yes.
Right.
Yeah.
And so I think if you have helped one child maybe more than the others, during life, you can, and I have seen people do this, adjust in the inheritance later on to kind of equalize it out. If you're going to do that, though, I think it's really important to make sure that you're explaining why that is in the document, even if you don't explain it to your children in advance, but just so that people come away from an inheritance with weird feelings about being shorted somehow on things that we don't expect. And so I think if you're going to acknowledge that you have made extra gifts to this child, explain that in your document. Because I have helped extra during life, I am now giving this child less. Or you can even include in the description, I'm making it equal shares, but we're going to reduce this share by this amount that I gave them before to buy a house.
And so I've seen, for example, where maybe one child or family member is a CEO, for example, and the other one, and it's maybe further along again in their stage of life. And then there's another child who maybe is still finishing school. Maybe they're younger, maybe they were a pleasant surprise, to their parents. And so they're not remotely at that same stage in terms of having completed their education, being in a similar wage range. And I've even seen where, someone who is very well established, where the family, very transparently, the parents have said, you know what, we're actually leaving nothing to that child. They're in great shape, never going to have to worry, but there's more need over here. Do you find that typically, again, I think so much we're going to keep coming back to today has to do with communication and transparency. But do you find that if that's communicated well, that typically, that as much as anyone can control the outcome, it's fairly smooth?
If it's explained. So for example, your example where you had a much younger child who is still in college, then usually they will explain that we have this later child and yes, and who still needs to finish their education. So there is more money here for that. I think explaining it is the key to that. Also, where that senior child in your example is a CEO and doing well, they are not going to feel as slighted that you're taking care of a younger child because they probably got their college paid for and things like that, when they were going through that as well. It's hard. So I would say if you change the example a little bit and the less successful child is not like still finishing college, they've just made different life choices. I think it's harder to treat them differently when they're all adults, just because they've made different life choices. Because this child went into software and is now, a Microsoft millionaire, and this child worked at Disneyland and is happy.
Or a teacher, right?
Yeah,
who should be paid that much, but unfortunately is not.
Right.
Yes.
Well, that is true. I just had that conversation at lunch today with someone. So I think that, communication is key there. The situations do get a little more complicated, perhaps like with that much younger child, when it's a stepchild, maybe you have your adult children from your first marriage and your second marriage, you've had a much younger child. That's another tough spot to plan for, but you do have to, make sure that you complete raising that child as best you can as well. And a lot of times what people will do is they'll set up a trust that will stay in place until that much younger child reaches a certain age, and the funds are used for their support or their education. And then when they reach that age, then it divides out equally.
So I think that's a great question around blended families. What has been your best approach in stepping into these conversations with blended families, and what have you seen work well?
So that's interesting, because I just had a new perspective from the child of a blended family than I had seen before. So a lot of blended families will keep the inheritances separate, right? And it kind of depends on at what point in time the remarriage happens. Did it happen when we were 40 or when we were 80? And are there your children, my children, and our children? So those get a little bit complicated. So families do it differently. Some families will say, my half goes to my children, your share goes to your children. Some families will choose to treat all the children equally. Your kids are my kids, particularly after you've been married 30 or 40 years, if the kids get along. But the new perspective on treating all the step kids equally that I got yesterday was from a woman who was an only child, and the step parent had 2 children. And so the parents in their wills had treated all the children equally. And she was like, well, I should have gotten 50%. I should have gotten my mom's whole half. So I was like, okay. So I had not interpreted that way before. I had always looked at treating all the stepchildren equally as you really have successfully blended your family. And it was surprising to hear a professional person that I work with to say, well, I felt a little gypped. Like,
Right. Well, and I think that's an interesting question, because there's also the generational question. So the third generation question. So to start with, a family might have one child with one of their own children, so grandchild of those who are giving, and third generation, and then another child, second generation, might have 3 or 4 kids that are in the third generation. And so I'm guessing that there are questions that have come up around what is equitable in terms of that very thing that you just mentioned. Wait a minute, if it's 50-50, but I have 4 kids and this person has 1, how does that trickle down to my 4? But also the person who has 1 not being penalized for having fewer children.
And I think that's kind of like the career question, right? Do you treat your children unequally based on their life choices, right? So the most standard description in estate planning documents is that I give it to my children, and then so if one of your children passed away, that child's share would trickle down to their children. So your one child, your one grandchild would get a 50%, and those other 4 would share 50%, and they would get smaller pieces. That's kind of standard. Sometimes families will skip their children and go ahead and make equal gifts to all the grandchildren, particularly if your children are doing fine. They are professionals, they are taking care of themselves. People will treat all the grandchildren equally, because you obviously love all your grandchildren equally.
We hope. And have you run into any, I guess, what are any challenges that might arise with generation skipping trusts, which I think is kind of one of the examples that we're referring to?
Well, if your child has predeceased you, it's not technically a generation skipping trust, because that generation has been removed from the scenario. At the federal tax level, if you do choose to skip down to grandchildren and leave your children out, there are potentially some income tax or transfer tax consequences at the federal level if you've got an estate over, $12 million, $13 million. But that's a
until it
pretty
sunsets,
complicated
right?
topic that's outside of our scope today.
Yes. Yes. And if there is also, I have several more questions. So for example, do people try to give secretly?
Oh, yeah. Oh,
I'm
yeah.
going to give to this kid over here. No one will know.
Hmm. Well, during life, it's pretty easy to gift
Mhm.
secretly, and that can be a complication later on, right? If you've given to a child during life and your other children don't know, or your other heirs don't know, sometimes afterwards there will be an argument between children saying, "Oh, well, were you sucking mom dry, while she was
Mhm.
here? And now you're still going to get half at the end too." So, um, but people get to do what they want with their money, and it's just trying to find a way that it doesn't cause friction and confusion and pain, after you're gone. I like explaining why you're treating people differently if you are, or why you've made decisions about what you do, because it offers some closure.
Mm.
If there's a dispute and they don't understand why you gave this child more than that one, or didn't give any children anything and gave it all to a charity, they feel hurt, and there's no opportunity to discuss it and get some closure, right? So I think that communication is important, whether it's in the document or not. I have seen plans where, like, the main document says to everybody equally, and then there's a secret document that's not for everybody's eyes, that is a codicil or an addendum to the
Mhm.
document that says, "But this child gets it in trust," or, because you didn't want them to have control. Or what's probably smarter is actually to leave it to all the children in trust under your main document, and then have a side agreement, maybe letting the one who you do trust, or whomever you do trust, let them manage theirs themselves, so that the one person that you feel needs assistance with managing their inheritance
Mhm.
doesn't feel like they've been treated differently or slighted.
Mhm. So I think what you're speaking to there are a couple of scenarios. Parents who might view a child as a spendthrift, or certainly many families have, at least, in many families, there is one who is challenged by addiction. Um, what have you seen work in those scenarios?
Well, so that is where people, what works is setting up a trust. But the thing that's surprising is trust beneficiaries are never happy to not get their money outright. So
Hmm.
that's why I think it's a smart strategy to leave it in trust for everybody in the main
Mm.
document. It also, leaving things to your heirs in trust, helps confirm that those assets are separate property, and maybe protect those from a divorce down the road,
Hmm.
or from creditors or something. But if the child can manage it themselves, then you lose some of that protection. But by setting up that main document where it's in trust to everybody first, then that spendthrift child, or that child with the addictions, or whatever the challenge is, doesn't feel like they've been pinpointed
Hmm.
as
So
not
they're
being
not
capable.
singled out, right?
Yeah.
And, often people I know, and this could be, I'd imagine, thankfully, I have not been through this experience myself, but I've certainly seen, we've seen a lot over the time here with our team. I would imagine that someone who has those stipulations of age built into their trust. Are you saying even drilling down to that level, so that across every trust, if one has age stipulations when maybe they acquire certain amounts of wealth, um, that it should be the same with the others? I'm guessing that's not what you're suggesting, but maybe it is.
It having similar terms in the main document is
Hmm.
what kind of evens the playing field, right? So if you're saying age, in the main
Okay.
document, right, I would say make that the same across the board, so that one person, who you really want restricted, doesn't
Hmm.
feel singled out. And then in the side agreement, you can say these other children can take over it or get it at a different age.
Mm-hmm.
But the one document that affects your spendthrift, treats them the same.
Interesting. Okay.
So, I mean,
Okay.
that's a little
Yeah.
shocking though, when you're walking through that as,
Right.
the financial advisor or the estate probate attorney, like, and here's the secret of thing. But you're trying to, help your children or your heirs still have a relationship
Mm-hmm.
afterwards. You want your family to still be a family. And these kinds of disputes can destroy families.
Which is really, I think, so much of what this conversation is about. I mean, there is the piece that is passing on one's legacy, one's own values and wishes, but then also once you're gone, as you said, we can only control so much, right? I've heard several estate attorneys recently refer to, a trust as sort of control beyond the grave, but you can only control so much. But hopefully, helping to maintain those relationships once you're gone to the best of your ability um, is really the goal. And again, back to communication and transparency. I do appreciate you saying, we review a lot of trusts here for clients, and some are clearer than others. And I appreciate you referring to communication not only in person, out loud, one-on-one, but how you communicate in the document.
Mhm.
Certainly, we see, a lot of boilerplate trusts and documents, but how much time do you all spend working with families and those who are planning around creating that language so that they can communicate those things that they may not have been able to communicate as well while they're living?
Sure. Well, when clients come to Heritage, so they are also working with an estate planning attorney who
Mm-hmm,
is actually drafting their documents
mm-hmm,
for them. So what we will discuss their estate plan with them and make some suggestions and have them go back to their attorney and work it out. And then I also like it when they bring us their drafts. So like this morning, I had some
mm-hmm,
clients and we walked through their drafts and I asked questions like, what does this language mean? What do you intend here? This is what that's going to do. And so we had a conversation, and then I gave some suggested language for them to take back to their attorney so that they can draft it into their documents. So we give them some ideas, kind of confirming, what do you want? What is your goal here? And how can we fit that in your documents?
mm-hmm. And so I think I'd love to go back to blended families. We have, and I'm sure you have examples. We certainly have a number of clients with blended families, potentially the couple, the main couple who's doing the giving, maybe of different ages sometimes, and then you've got not just second generation, but then as we've been discussing, you've got various forms and numbers in the third generation. Um, what are ways that you've seen that handled well? Because also you're talking about communicating with so many people. And
Well,
those
and
those
yeah.
they may all be one happy blended family and they may not.
So some things that have worked really well, um, is sometimes life insurance is the piece. Like if you have a second marriage and
Mm-hmm.
one of these spouses is going to pass away first, right? How do you take care of the surviving spouse, but also not have children feeling like they're sitting around waiting for surviving spouse to die to get their share? And
Mm-hmm.
so, life insurance can be used in that, either to make an immediate gift to children, when the first spouse passes, or to the spouse and let the children have their inheritance then. So that is,
Mm-hmm.
kind of one of the ways I've seen it work well. Or make immediate gifts of some amount to the children when the first spouse passes away. Maybe it's, depending on the size of it, like maybe it's $50,000, and then the rest is held for the surviving spouse. And then when they pass away, then the rest passes out to all the children, either 50-50, like, wife's piece, spouse number one's piece goes to that person's child, and spouse number two's, in assets go to their children. I've seen that work as well. It kind of depends on the family and what the assets are and what the situation is.
And when one is having these conversations, Stella, I would imagine that I know, we do a lot in terms of bringing clients in and saying, "Hey, please bring your kids, second generation, third. Let's talk about your investments. Let's talk about what your intention is down the road, or we'll help them with their Roth, their 529s, what have you." Um, are estate attorneys and your trust company, for example, available to help guide those conversations? Um, I know we sometimes have clients who really want to have the conversation, and maybe their heirs don't want to talk about it. They don't want to think about that person dying.
Mhm. That happens, and it's funny because I've been in this field for so long that I sometimes wonder if I'm a little bit callous in approaching it because I don't have any hesitation talking about it, right? And then you'll get people like, "Well, I don't want to talk about it," or "I don't want to tell my children." I've
Hmm.
had clients who didn't want their heirs to know anything, and that's a valid option too. But I try to warn those clients, okay, but how is this going to play out?
Hmm.
You know, not we are certainly willing to have those conversations with heirs, but at the same time, estate plans can change, right? And
Right.
what the people your clients have in place today might not be what the scenario is 10 years down the road. I saw one family where the step parents, blended family, they had drafted estate planning documents. The children knew what was in the estate planning documents. But then before the husband was the first spouse to pass, and before he passed away, they had spent all the money and the estate was completely different than what they
Mm-hmm.
had planned for. So then there was litigation between, the deceased spouse's children and surviving step parent because they're like, well, we were supposed to get something. Well, there's nothing to get,
Right.
and so that's so I kind of have to leave it. I think you have to leave it up to your clients and say, your family best. Here are the possible scenarios on how these can play out. You can have the conversations, but then you create some expectations,
Hmm.
and so if things change, you have to have the conversations again, or you can keep it a mystery and keep it close to your shelf so you avoid all the awkward conversations now, recognizing that it could cause more problems down the
They're
road.
going to happen later, those awkward conversations at the very
Yeah,
least.
at some
Yes.
point, yeah.
Yes. And I think you and I also talked about scenarios in which, and we sort of, I alluded to this earlier in, with the scenario of maybe a different age range or someone who's very successful. But I believe you've shared about encountering those who want to just disinherit someone.
And it depends on why. So first of all, if
Hmm.
you're going to disinherit someone, you can do that. You can leave your money to whoever you want. They used to say you had to leave them $1. You don't have to do that anymore. You
Okay.
just have to identify them so they know that you didn't forget, like, oh, I have 6 children, not 7, you know. So you have to be clear. But if you're
Mm.
disinheriting someone, understand why. I have had clients who proposed, you know leaving one child less because they didn't agree with their political views, and
Mhm.
I actually refused to do the planning for that person. But if you have a child or an heir who has stolen from you, or something like that, that's a legitimate reason for doing that. And I would just say you just want to be clear that that's what you're doing, and why, and maybe communicate that why. I have also, this is one of my favorite families. I had a blended family, and when the surviving parent passed away, he intentionally left out his stepson
Mm.
and or one of his stepsons. There were multiple children on both sides. And the siblings, all the remaining siblings came together and said, no, we're going to change
Mm.
this. And he gets his share. I was like,
Mm.
oh, thank you for being good people. So sometimes people, when drafting their estate planning documents, will have a very rigid view, of what
Hmm.
they think is appropriate or what they want to do. And and there is a mechanism available for their heirs to fix it if they disagree with what the
Hmm.
deceased party has done, which is a nice option if the family agrees.
Right. And that I have a question on that, and I want to remind everyone who's listening and watching please, if you have any questions, we'll save a few minutes at the end for Q&A, but feel free to send them in through our chat or Q&A feature here on the webinar. We do have another one that's come through. I wanted to ask on that point before I get to this other question. I know there are people who have, and I've had clients speak to this, oh, I'm just going to leave it all to so-and-so. They'll know what to do with my money. They'll know what to do with my assets. How do you respond to that?
Well, I explain it's a bad idea. First of all, you're placing a lot of responsibility on that person to get it right, and they may or may not fully understand your wishes. Also, you create an opportunity for that person to just take it and go.
Mm-hmm.
Additionally, if that individual wants to carry out your wishes, what they are doing then is taking an asset that is now theirs and making a gift to your other heirs.
Mm-hmm.
And that may require them to file gift tax returns and use up their own personal, like, lifetime estate tax exemption amounts. So if you want that person to make gifts, I explain and I urge clients to make it explicit in your will or your trust so that no one's guessing, and that your wishes are very clear. So then if that person is your executor or your successor trustee, then they can just carry out your wishes as it's clearly written in your document.
And also not having the burden left on someone who is grieving of having to guess and hope that they're honoring your wishes and your values and your legacy. Yes.
And the other side of that too is those expected heirs who have now not gotten anything, they're going to second guess everything that person does.
Right. And possibly be very hurt and not understand.
Oh yeah.
Why were we left nothing? Is there ever an opportunity to challenge what one might view as an inequitable distribution? And if there have been, litigation, can you litigate at any point? What does that look like?
So any heir can challenge anything and argue it's inequitable. What that looks like then is they have to either be able to prove in front of a court that the deceased party was unduly influenced, into changing their documents, or didn't have capacity to, sign their documents and make their own decisions. And that's just a painful and expensive process. When I was doing estate planning, I used to joke, like, my biggest estate plan I ever did, I made maybe $7,000, but a good messed up probate, I would make $30,000 or $40,000 like that. So it's important to plan and try to be very clear. Right.
That just prompted a thought that I may have just lost. I think, for so many, the hope is that they've got everything in place, and then there are certain things that are left out there that someone, that have just been overlooked. How is that generally handled in terms of our conversation here? When you go to probate and the rest of the estate and division equally or equitably?
That is a tricky question because there are two pieces to your estate, right? So when you've passed away, whether you have a trust or something, there is, the things, the assets that are governed by your document, your will or your trust document, but then there are other assets that have beneficiary designations. And so they will pass according to those contracts, basically, and are outside of your main document. And some people, will treat everything the same. If everything's getting divided between all three kids, every asset, every retirement plan has the same beneficiary designation. But other people will plan differently and will choose to leave this Roth IRA to the grandkids so that they get it tax-free, and they will choose to do other things with this money. So that's a more complicated piece of planning that kind of has to be walked through with the clients and make sure they understand what they're doing. Because I have seen estates where the beneficiary designations left like a retirement plan to just one child, even though the will left, everything to all three.
Mm-hmm.
And just making sure that the clients understand how that's going to play out and be different. And is that what you intend?
And in that case, do you advise them that somehow that be stipulated that it is a part of, so let's say there are 3 children, that is a part of that child's third of the estate?
If that is what they intend, we
Mm-hmm.
can put that in there.
But
Mm-hmm.
but it may not be their intention.
Right.
Yes. Yeah, there's so many, certainly with, individuals who have various accounts and assets, I can see how that could get also just very complex.
And one of the
We
tricky
have
things
seen that.
in planning too is for most assets, when they pass to your children, they pass to them income tax free, right?
Mm-hmm.
Because they get a step up in basis. This is tax geek talk. Sorry if you don't care. But retirement plans like traditional
Mm-hmm.
401ks and IRAs are still subject to income tax in your heirs' hands. And so if you give, one
Right.
child your 401k and the other child gets a house, you want to think that through, right?
The
And
tax
is
implication.
that what
Right.
you intend?
Right.
Because maybe that child, while the 401k might be 400,000 and the house is 400,000, that child with the 401k is going to pay income tax on that.
Mm-hmm.
And that can be hard to plan too, because then that's going to be at their income tax rate. And what is that? And that's where your financial advisors come in to help you out in the end.
We've also, I know, seen, and I'm sure, you've seen clients, and also we're getting to an age where we have friends who are caregiving for family members, parents. And I can imagine that there are those who want to reward the child or children who are caregiving, and they might think, oh, well, and those individuals may have given up income
Mm-hmm.
also to do so. Is there a way that you've seen that done successfully?
Ideally, there is an employment agreement and you would pay that
Mm,
child in accordance with an employment agreement,
mm-hmm,
so that is, because if you need caregiving, you're going to need caregiving. You're going to either
mm-hmm,
pay for it or have your child do it now. If you can't afford, to pay that child while you're receiving the care and it's coming out of your estate, I would just be very clear in the planning documents again and describe, how much you want that child to get extra for caregiving and why. What happens a lot of times in those scenarios is someone at the end of their life who's being cared for by a child, that child is the only one they're very close to. There
mm,
may only be one other or two other children who live far away and are not in involved, certainly on
mm-hmm.
a day-to-day basis, and maybe they're estranged. And so then that parent will leave their whole estate to the child that took care of them. And I would just say, make sure that that's clear in your documents, that
Mm-hmm.
that is why, so that those other children, a lot of times those other children may not come back and challenge it, but sometimes they may. You wanted to do that
Yeah,
because you loved mom and no one ever asked me to come help.
right.
So that's another tricky situation that can make it really difficult.
And I don't know if this is an
Mhm.
easy question to think of scenarios. When we're looking at this overall idea of equal versus equitable, equal, I would imagine, is, challenged uh, far more infrequently as compared to something that looks inequitable, even though it might be very fair.
Mhm.
Um, what are scenarios that you've seen that just haven't worked and where you knew going in, I wouldn't recommend this. It's probably not going to play out well. Are there any things that, people can avoid?
Where there is usually a problem, actually, a scenario I've seen multiple times, is there is a child who works with the parent in a family-owned business,
Mm.
like a business that the parent started. Maybe the parent was in real estate or, whatever kind of company it is, it doesn't matter. But if there's one child that's involved in the business with the parent and the parent is calling all the shots, and then even if the parent's will divides everything equally, those other children will come back and challenge everything that was done in the business by
Mm.
that child who was involved. Well, why did you give $10,000 to the high school marching band? And that child is like, Mom told me to,
Mm-hmm.
and it's usually the mother that ran the business in these scenarios too, which is kind of funny. But
Interesting.
that's a place where I've seen there's almost always a challenge in the estate distribution because they're challenging actions that were done before death in the business,
Mm.
not really as, because they're before it even gets into the estate, right? Like the state might be fine, but
Right.
there's that before death activity is the one that gets challenged quite a bit.
And
And
is there
so
any way to avoid that?
I think, it's unfortunate because that child who's working in the business has to be defensive, right?
Mm-hmm.
Make sure, the parent is signing everything, or make
Mm-hmm.
sure there's explicit corporate authority,
Mm-hmm.
or the power of attorney is very explicit on the approved actions by the child working in the business. It's a challenging one and frequently ends up in litigation later.
I think that's another good point. So if there is a family-owned business and that business is left to one child, and I would imagine that's in a situation like that, it would probably be the child who's been working with the parent, with this example. Um, and then there could be siblings who come back, and even though they've not been involved with the business, say, I want to be involved now, or I want a part of it, or how, is there a good way to do that equitably, or what have you
What
advised
the,
in the past?
if they're going to leave the business to the child who's been working in the business, which does make a ton of sense, then they need to kind of balance it out so they
Mm-hmm.
can equalize the estate amongst all the children. That's the best way. And so what happens then is they'll get a business valuation as of the date of death, and then hopefully there are enough other assets to balance it out. Otherwise, if it's just part of the bulk of the estate, what the other alternative is that all the children come in as co-owners or shareholders or members of the LLC or whatever. And then that's where they have the authority then to start
Mm-hmm.
challenging those pre-corporate actions. Ideally, that family business, if there's not enough assets to equalize it out, the business is set up in such a way so that that child who's been managing the business can continue to manage it while all the other heirs are co-owners but maybe don't have decision-making authority, so they can receive income and let the kid just keep running the business like they have been.
Okay. And certainly I know, I've had clients talk about, well, maybe this child who's in the business will receive the business, but these real estate assets over here will be left to the other siblings.
And what's a
So
nice option on
yeah,
that, sorry to interrupt,
no.
is to build into your documents like a buy sell option. And I've seen
Mm.
that a lot where they will say, the all co-owners and the child who's in the business has the option to buy them out
Mm-hmm.
at maybe a preferred price that's even spelled out, either a formula or a dollar amount
Mm-hmm.
in the document, so that then that child has the opportunity, but everyone still gets a share.
Great. Okay. I want to leave some time if we have additional questions from any of the attendees. Now is your chance. Certainly, you can reach out to us later, but please, if you have a question, you can put it in the chat or the Q&A. And while we're waiting to field questions, Stella, how do you sort of approach these conversations initially with individuals and couples or families who are at the outset of planning their estate and asking this question of themselves, which, do we want it just to be split, or how do we want to do this?
I just ask the questions with them, okay, so you have 3 children and you're saying you want to do this differently. Why is that?
Mm-hmm.
What will happen down the road? What if this happens? And then what that, I just kind of walk them through as many scenarios. That's kind of always been my job, right? To come up with the horror scenarios where things don't work out.
Mm-hmm.
Hopefully things do and everyone's peaceful and is kind to each other in this process. That's one of the big things I like to point out to people, like everyone's going to be grieving. So
Mm-hmm.
let's try to set this up so that people
Yes.
have the capacity to be kind to each other
Mm-hmm.
and help them get where they're going. And so I think better communication is the way to handle that.
Mm-hmm. So we had a couple of questions come in. Can you explain the difference between an estate attorney and a trust attorney or a corporate trust company?
Sure. So, well, an estate attorney is, an estate planning attorney is the attorney who is drafting your estate planning documents, whether that be a will or a living trust, your powers of attorney, your healthcare directives. Hopefully, your estate planning attorney specializes and they know what they're doing, so they know the questions to ask. I've seen, you know, insurance defense attorneys draft wills and it's a mess. So then when you pass away, whatever your estate planning documents are, so if you have a will, you have an executor and you name someone whose job it is to come in and gather up your assets, pay your bills, and distribute your assets according to your documents. You can, most people probably choose like their oldest child,
Mm-hmm.
or, if they're older and their children live further away, maybe a good friend. Then there are corporate trust companies like Heritage, or banks have a trust department, and there are professional fiduciaries who carry out that role, who will also, like the same thing as a successor trustee under your living trust. By having a professional fiduciary in this role, it allows your family members to just be family members. You've got an
Mm-hmm.
independent third party who's not emotionally involved in carrying out your estate. So, and also your professional fiduciary knows what the obligations are and the steps that they're supposed to follow through. One of the conversations I had this morning, I had clients who had named one child to be the successor trustee of their trust, and they had multiple children. And I said, okay, but does your child know what he's supposed to do? And is he going to
Mm-hmm.
report to the other children as frequently as he should? Because one of the other problems that comes up is when you've left one child with all the control and they have the responsibility to pay bills, settle assets, make distributions. And if they're not keeping the other children fully informed, then that's another opportunity for bad feelings, litigation,
Mm-hmm.
distrust, and scars on your family going down the way. So I have not always been a huge, trust person. But I think for certain families, it's the right option. I had a family one time that was a large Mormon family, and there were 12 children.
Mm.
And when you have 12 children, there were like 3 little mini family groups of kids
Right.
in there. And so having, a professional trustee step in to
Mm.
handle that not only took all that weight off the one child who had kind of been in charge, but then they all knew that the professional was going to treat them all equally and
Mm.
in accordance with the documents.
And before I get to this other
Mhm.
question, you and I have talked about, I could imagine there are those who, for various reasons, but one of them being, well, I also want to be fair when I name a trustee. Therefore, I'll just make both children co-trustees. And I know you have thoughts about that.
I do. I think trustees is challenging because they both have to agree to
Mhm.
get anything done. And if they don't agree, then how do you resolve that? So I think your
Mhm.
documents have to say what is the dividing line. And so like the clients I met with this morning, they said, well, we'll have the professional trustee and come in and be the equalizing voice. I said,
Mm.
okay, but why don't you just make the professional trustee the trustee in the first place,
Mhm.
instead of having us come in after there's already a dispute?
Right.
So having one person who can make a decision is important, I think, because it makes it easier. If you've got 2 children or 3 children
Mhm.
who are spread all over the country, you can't get them on the phone at the same time. You can't get everyone available to sign documents that you need to fully administer the estate.
Okay. So a couple of other questions, and this might look well, I think they're asking about the mechanics versus necessarily the timing. But someone is asking how invested assets are divided at the time of death, and I can certainly speak to that as well.
It can be done either of two ways. Either the invested assets can be liquidated and then just distributed as cash, or they can be distributed in kind. But if you're going to distribute them in kind, you again have to think about income tax consequences down the road. And you can't give someone the good stock and someone the stock that's going to go out of business in a year, right? So usually with invested assets, they are liquidated. But I
And
have seen it go other ways.
Yeah, we've certainly, I can speak for us, we've certainly distributed, a number of estates where they've been distributed in kind, and yes, and that can be done, equitably. It's honestly, people, I think, sometimes look at that. It's work that we do, and it's work we do frequently. But also hopefully you're sort of planning for that eventuality, knowing that these are going to be divided one day, and then what needs to be liquidated can be, if there's not a way to do, a certain stock or bond or something equitably.
And that is something I've done before with 401ks that are getting distributed out. We will distribute it equally in kind so that each individual heir can make their own decision on when they withdraw that money based on their own individual income tax circumstance.
The other question is, and you might want to speak to this generally, they ask generally, what is a fee or a general fee for professional fiduciary? Is it a percentage of the estate? Is it a flat fee?
Usually it is a percentage of the estate, usually about 1 maybe or 1.2% of the assets. Other trust companies like we do either a percentage of assets under management, and we'll do an hourly component for special projects. So there's not going to be a flat fee really, because they can't anticipate how much work is going to be involved.
Right. So I'm going to go to this one question first and go back because it's along these same lines. Who appoints the trustee?
Hopefully you've written it in your documents.
Yes, they asked over time, but I think we just lost her for a moment. She'll be back, ladies and gentlemen. I will say from what I know that there are, whoever the grantors are naming the trust. They're appointing hopefully successor trustees. I think for any who attended our previous webinar on the foundations of estate planning, Julie Rivers had referred to having a deep bench of trustees. So you wouldn't necessarily want to just name one trustee and not have a successor or a couple of successor trustees. And that's another option. You could have, one child listed, or one family member listed as a trustee or a trusted friend, and then possibly the successor trustee is a corporate trustee, a trust company. And it looks like we did lose Stella. I'm imagining she's trying to sign back on. And I have a question. I might need someone to clarify. They've asked how they can account for extra money. If their estate increases past the value of what they intend to give away. I think that's, Stella can certainly speak to that, but that's where you are weighing initially when you're creating your estate, distributions and beneficiaries. Are you looking at dollar amounts or percentages? So for example, if you have a charity to whom you are giving $25,000 and your estate increases, and down the road, oh gosh, I'd like them to have a larger piece if my estate is has a higher value at the time of my passing. You might want to consider a percentage. And I am imagining that there's also a way for saying, if the estate increases by this percentage, that you could probably build something in around that as well, that, if the value goes up this amount. But I think to keep that cleaner, I'm guessing that Stella would advise to looking at percentages, because then as the estate value grows, which hopefully if you're invested, it will do over time, it is built to grow. And therefore, if you stipulate specific dollar amounts, it will be limited to that. I don't know if Stella's going to be able to get back in, and we're almost at time. So if you have any additional questions, please do reach out to us. We can send your questions to Stella, and we work with a number of other estate attorneys. And we also have other Heritage Trust and some other trust companies to whom we can refer clients or anyone who's interested. And I'll just close by saying, we always try to encourage this as well when we're meeting with clients. But I think, as we've spoken to today, just a lot of communication and transparency can be the greatest prevention against, creating a lack of harmony after you're gone. So we will, over the next couple of weeks, we'll have the replay available if you missed anything. And I am thanking Stella Pederson in absentia, and thank you all for joining us today.